You are listening to MyHRBuzz, brought to you by MyHRConcierge. Hosted by Chris Cooley, we'll bring you various topics and guests to shed light on the often confusing world of HR and also employee screening. We'll be putting the human in human resources.
I want to thank you for joining us today on MyHRBuzz, the podcast. I think we've got a great topic for you. We're going to talk about leave, which is one of our most common questions that we get. And so we thought it would be a great topic. And for that, we've got Emily Frederick, who's a senior human resources consultant with MyHRConcierge, and also our leave guru. And so I appreciate you jumping on today.
Yeah, thanks for having me back. This will be a fun conversation.
Yeah. And so, really, as we think about leave, I think the first thing that kind of pops in our head is there's a lot of different levels, right? State, and federal, and municipal even at this point. But maybe we start at the federal level. We talk about a little bit about FMLA and how that affects employers and employees. And so tell us a little bit about FMLA and what it is at a high level.
Sure. So the Family Medical Leave Act was passed in 1993 as a way for there to be something on the federal level for all employers to abide by, that it grants employees really the ability to have some work-life balance. So employees are able to, if they are qualified, and if their company offers FMLA because their company is a covered employer, then they are able to take up to 12 weeks of unpaid time off to expand their families, care for a loved one with an illness, or care for their own serious medical condition. And there's certain eligibility criteria they have to meet, and even certain eligibility criteria that companies have to meet before they can even offer it.
So from let's look at good thing. So from an employee perspective, who is eligible for FMLA?
Well, if they work for a covered employer, first of all, then to be a covered employer, a company has to have at least 50 employees that live within a 75-mile radius. And then those employees, in order to be eligible for FMLA, they need to have worked for the company for at least 12 months, worked a certain number of hours within that 12 months, which is 1,250 hours, and they have to have a qualifying health condition.
Now, does that 12 months have to be concurrent?
It does not. Actually, if an employee works for a set amount of time and then leaves for a little while, then comes back, that time can all count.
Okay, which I get is big because in a lot of the industries that we work in, which we see a lot of rehiring and those things. So I guess these companies really need to kind of take into account all stints within that 12 months or within that period. So if I'm right, they go back. Is that 12 month? It doesn't have to be concurrent. They do have to work, but in that 12 months, it can go back like almost 7 years.
That's right. So a month here and a month there over the past 7 years, an employee can be eligible.
That's just the record keeping for that is tough, especially as I mentioned in a lot of these. Like we work in a lot of grocery and those kind of industries, and you have people coming and going all the time.
Absolutely. Yeah. The record keeping is actually one of the strictest parts of the FMLA. I mean, there are very specific rules on, payroll information has to have been kept, and any request for leave has to have been documented, et cetera, et cetera.
Okay. And I guess, is it any employee that works 1,250 hours? So therefore we're taking out the full-time and part-time designation out. It's just any employee.
Yeah, that's right. So if the company is eligible, anyone who has worked, and then here's where the timeframes really come into play, because the employee has to have worked that 1,250 hours within the last 12 months. So, the total 12 months is the first piece of the eligibility. And then as long as they've worked 1,250 hours within the last 12 months as of the date of the leave request, then they can be eligible.
Okay. Now that makes sense. And so, all right, so that's kind of from the employee perspective, who's eligible. And if we back up a little bit, we talked about employers that were qualified employers.
Mm-hmm.
So they have to have the 50 employees within the 75-mile radius. So if you have you could have 100 employees, But if you have one in New Orleans, you have 10 in New Orleans and 30 in Dallas, and they're spread out. If they're outside of that 75-mile radius, they don't have to provide FMLA.
That's right. So the company has a central work location, maybe a main office, and they would have to have at least 50 employees within 75 miles of that main office.
Okay.
Now, if they have an additional 25 or 30 employees elsewhere around the country, as long as they have that 50 within that 75-mile radius, those employees around the country are still eligible for FMLA, but the company has to be compelled to offer FMLA. They would have to have that those 50 employees within the 75 miles of the main office or the reporting location for the employees.
So that's kind of how they factor in remote workers. So if a remote worker reports to that main office, even though they're in California and the main office is in New York, they would still get the FMLA, eligible.
Yeah, as long as, again, 50 employees within that 75 miles of that main office, employees anywhere else are still eligible.
So let me ask you this question. So I've got a main office that's got 50 employees within the 75 miles.
Mm-hmm.
And then I've got satellite offices. So I've got a satellite office that has 30 employees that's 200 miles away.
Mm-hmm.
Do they fall within that? Or because they're an office, not a quote remote worker, but an office that's outside of that 75-mile radius, did those employees, are they eligible for FMLA?
No, if they are reporting to that satellite office, that's where they get their work instructions. That is their work location, and they actually do not qualify for the FMLA.
Okay, so you have to have like a doctorate in leave to figure all this out. Is that what we're saying?
Basically, yes, an immaculate flow chart.
Okay, well, good. So, and do we know any? All right, so we have that main office, right? And we've talked about the satellites. One of the things, I was talking to a group the other day, and they're a consulting firm, a real estate consulting firm, and they have they were under 50, but let's say that they had 50 employees. They had no office, so everybody was worked out of their home, all 50 employees. We talked about how remote, if they are going back to a main location, if they report to that main location, that's where they get their eligibility. What do we do, or is there any guidance on how we address this with these companies that are now just fully remote? I mean, they don't even have office space.
So, first of all, you would consider each employee is getting their work instructions from one place that is not their home, right? So the government says your residence is not a work location. You're getting your guidance from somewhere else. However, if it's like you mentioned, and the person they're getting their guidance from, that say the president of the company actually communicates with all 50 employees, and he lives in one place, and there are not at least 50 employees that live within 75 miles of his location, then we don't know really. So the Department of Labor has not issued guidance on what to do for fully remote companies. It's such a new concept, and we all know the government's a little bit behind on big things that come in. It's tricky, and a company would really just have to make some determinations on their own there, and that can be a little bit precarious. But there's no federal guidance.
Okay. I mean, they've only had 4 years, so I guess it's probably, right. I understand. So, right. Okay. So I guess in those situations, it really is more of it's a gray area, and it's just kind of a company's going to have to figure out which side of that gray they're going to fall on, whether they're going to offer it just to be safe or how they do that.
That's right.
Okay. So what is, so we've got employee, they're eligible. What's an eligible situation? So what kind of constitutes where they can go out on FMLA?
Sure. Well, it's the types of situations it covers is expanding the family, so birth or adoption are covered. Any serious health condition is covered, and caregiving for an immediate family member is covered. The definition of family member is typically a parent, a spouse, a child are the most immediate definitions. And for federal FMLA, the definition of a child stops at about age 23. So it typically can't be any child. An adult child is typically not covered.
Really? Okay, I didn't realize that. So I didn't realize they put age limits because it seems like your kid's always your kid, right?
I know. Yes, I agree. But yeah, it's a little bit tricky when they get older. And now there are special circumstances, of course. So if a child is truly dependent on a parent, so if it's a special needs child, those are still covered.
Okay. So so in these situations, and it sounds like it's really immediate family, grandparents. It sounds like even in-laws may not be covered.
That's right. For federal, those are covered. Sometimes those are covered under state laws, which are a little bit different, and that, of course, is just how they all intertwine, and it all gets tricky. But for federal, it's parents, children, spouses.
Okay. And so how long do they get?
They get 12 weeks in a specific 12-month period. So a company would have to decide what that 12-month period is. There are a few different options. It could be a calendar year. It could be a rolling 12-month period. But they get 12 weeks, up to 12 weeks of leave, determined by the nature of the illness or determined by the nature of the need for the leave, usually maybe with a doctor's certification saying how much time they need off of work, but they get up to 12 weeks. Okay.
Now, do they have to take the 12 all at one time? Or say, for instance, maybe they have like cancer where they're going and getting chemo and it's not a need that's concurrent.
That's right. So intermittent FMLA leave is entirely possible. And at that point, it just has to get broken down into 480 hours. And so an employee technically gets 480 hours of leave that they can use within 12 months.
Now, are there increments you have to take that 480 hours? So, for instance, if do they have to take a day at a time or an hour at a time, or is that more company policy?
Yeah, that's pretty much driven by company policy.
Okay.
And a lot of companies will require at least a half day, but they can allow it to be done incrementally by the hour. So say an employee has a standing therapy appointment every Tuesday from 12 to 1, then that 1 hour per week can be counted.
Okay. Well, that's good. Especially, like I said, I mean, there are instances, but I also get the record keeping side too, right? Having to start tracking that. And so I guess from an employer perspective, and we'll talk a little bit about the employer responsibilities later, but, and you mentioned it earlier, the record keeping on this is so important. And I know, one thing for a lot of these employers, my assumption is they're tracking it probably through payroll. But a lot of times if somebody's out and they're hourly, they're just not putting hours in.
That's right. And so if someone's out, whoever is the person in charge of tracking the leave will need to know if that person was off of work for the thing that they have approved FMLA leave for or not. Employers can require doctor's notes every single time someone is absent from work, even if it is on a recurring intermittent basis. They can require a doctor's note so that the leave is accurately tracked.
Okay. Yeah, because I could see where that could get. Yeah, because that's a good point I hadn't thought about. Specifically, if it's intermittent, it could be that they're off, but maybe they just had PTO that day. Maybe they had something that they were going to, and it's not FMLA. So there's a lot of coordination within this as well.
Oh, yeah. Yes. So, it's not always typically, or I guess in smaller companies, it might just be a payroll person that's keeping up with it. But a lot of times there is someone who manages the leave, a benefits person could be involved, and then they'll have to coordinate the times off along with the approved absences.
Okay. Well, so okay, so that makes sense. So now we kind of know what it is. We know why they get it. We know how long they get. What are the responsibilities? So how does that employee, what protections do they get as part of this, and what are their responsibilities to make sure that they get it?
Well, it really starts with the employer. So if an employer offers FMLA, or if they are a covered employer, then there is a poster that can be printed out from requested from the Department of Labor, and that has to be displayed to every employee to let employees know that FMLA is available if you're eligible for it. Employers can display that physically on a poster, or they can actually just put it on their company intranet. It can be displayed electronically. That's not a problem.
Okay.
And then if any employees are eligible for FMLA, if you have people who you have had employed for longer than 12 months, it needs to be in a company handbook. Like, there needs to be a paper policy that is given to employees. And I say paper, but that could also be electronic.
Right.
And then if an employee needs leave, at least they've been provided with the fact that the company is a covered employer and that FMLA is available to them. And so typically what happens is an employee says, I need to take X amount of time off for a medical condition. And then it is up to the employer to let the employee know that they are or are not eligible for FMLA leave, and explain to them their rights and responsibilities, which comes on a piece of paper from the Department of Labor. And they have 5 days to do that. Within the 5 days from the time the employer is made aware of the need for leave, those rights and responsibilities have to be in the hands of the employee.
Okay.
And then that explains everything to the employee, whether they are eligible or not, and then what it means that they are eligible.
Okay. Now, okay, so they have the paperwork, and to your point, these are forms that you can find on the DOL website. So they basically, it's hard not to get it right
Yes.
with that, because it's there. Now, there are questions that company has to answer. One of which is a common question, is, what do I do with benefits? Which will be on that. Because I know I was talking to a group one time, and it seems like that's always a question, is what do I do with benefits while employees are on FMLA? What they did is they just paid the whole premium for the employee for their full 12 weeks, because they didn't think they could charge the employee premiums, the employee share during that time. So how does that work? How do the benefits work within that period?
Yeah. So every company is going to have to set their own policy and decide. The employee has to be allowed to keep their benefits for the 12 weeks of the leave. So FMLA provides job protection and benefit protection. And what that means is, if the employee is willing and able to make their standard premium payments, so their employee portion of the payment, then they have to be allowed to make those payments during the leave and keep their benefit.
Okay.
An employee can choose to not keep their benefits during the leave. They can say, I'm not going to be able to pay for this, and I don't want to have to owe money for it when I come back, so please turn my benefits off. Though if the need for leave is medical, who would want to be without their insurance while they're dealing with a medical condition? The company can certainly choose to pay the entire premium for the employee, but they can also certainly set a policy that the employee must make their standard employee-only premium payments while they're on leave. And then the company can actually terminate the benefits if the employee does not make their benefit payments while they're on leave. It would need to be written in a company policy that if we don't receive payments after a set grace period, then benefits will be terminated.
Okay.
But because the benefits are protected, as soon as the employee comes back to work, they have to be reinstated immediately to those same benefits with no waiting period.
Okay. No, and I think that makes sense. So essentially, it's that employee can do whatever they want with those benefits in those 12 weeks.
Yeah, it's the employee's choice for sure.
Yeah. But I guess it's important that the employer has that information on how they want that to handle those benefits, and then also the consistency of that between employees, so that they're not do they have the ability, because depending on that, to your point, that person's situation, it could be that they're out for medical, so they want to keep those benefits. But I mean, can they vary that? So, because some people, it may be that they don't have any income during that 12 weeks, and they're like, I need my benefits, so I'll just pay you when I get back. How does that work?
Yeah, that's also an option that a company can have. So one of the ways we allow a company to choose when I'm writing a handbook, one of the ways we allow a company to write that policy is to say that the method of payment for the benefits will be determined at the time of the leave.
Okay.
And so, because just like what you're saying, every employee has a different situation. So if the company says across the board, every employee will get to determine how they're going to pay for their benefits at the time of the leave, then that's totally fine. Many companies do have a policy where an employee doesn't have to make the payments while they're on leave, because in most cases they're not being paid. So, and
Right.
it's not as though benefit premiums are necessarily cheap. So they'll allow a company to pay when they come back to work, to set up a payment plan. And again, it can vary from employee to employee, as long as everyone is given the same opportunity by the company and there's not any room for discrimination, then that's definitely a fine policy.
Okay. Good. Now, so they've left, and we'll talk again. We'll talk about some employer responsibilities, but they've left, and now they come back. So a lot of times in these companies, even though they're 50 employees, a lot of these companies are smaller, or they have very key employees. And there may be somebody that leaves that, you know what, I just can't have somebody. I cannot not have somebody in that position. And so I have to backfill. And so when they come back, what's the company's responsibility? Because they have to have, they have job protections. What's the company's responsibility to that employee as far as the job they come back to?
There are two different situations. So in general, an employee must return to the same or equivalent position with the same pay and the same range of job duties. Now, there is a situation, a company can have a policy that key employees are not afforded that particular protection. But in order for someone to be a key employee, they have to be among the higher salaried employees in a company. And they have to have a position that typically they are the only person in that position. An employer has to notify an employee that they are a key employee at the time that they request the leave, and they have to be notified that they may not be coming back to the same position. But when they do come back, they would still need to be making around the same pay and have around the same duties, but it may not be exact because they were a key employee.
Okay. So for non-key employees, it sounds like what they would have to do is they would just have to give them a job that obviously pay has to be the same. Duties could vary a little bit, but it needs to be in the same rank.
Yes, the same level of responsibility.
Yeah. Yeah. Okay. No, that's good. And so also, if we back up a little bit to the employer part, we talked about the notice of rights and responsibility. We have to get that within 5 days of learning. Walk us through those next steps. What's left? So do we get doctor certification? Do we get, and then as they come back, do we get return to work documentation? How does that work and flow?
Sure. So it sort of depends on what the need for the leave is. A company in general can always require a physician certification for every need for leave that has to do with themselves or a family member having a physical illness or injury.
Okay.
A physician certification can never be required for leave to bond with a new baby. So if it's new parent leave for a dad, the company cannot require a physician certification for that because there is no physician certification.
Right.
Now, if the need for leave is physical, a company can always require a physician certification, but they don't have to. So a company knows good and well that their employee is about to have a baby and is going to need the entire 12 weeks off to recover from that childbirth. They don't have to get a medical certification for that. We do always suggest that companies require a return to work notice, a release to work from a physician that includes any restrictions or no restrictions that an employee may have. And I would always request a return to work notice, even if someone was off work for having a baby. Then I would say, you don't have to have a medical certification. We know what the need for leave is and about how long you're going to be off work, but we will require your physician's release for you to come to work. And then there's a lot of protections there for the company if they do always require a physician certification, because the physician certification is going to tell the company how long the employee needs to be off work, when the physical ailment commenced, when the recovery period is expected to be over, so that they can really do their planning for coverage for the employee and things like that.
Okay. And so what happens at the end of the 12 weeks? So they get their return to work information, and it says, you know what, they really don't need to come back to work for another 2 weeks. What happens at that point?
That is the beautiful place where other laws and other regulations come into play. And at that point, we're actually no longer dealing with FMLA. So the job is no longer protected. The benefits are no longer protected, but the company may have a duty under the Americans with Disabilities Act to allow that employee to take the additional time off because their physician's requiring it. They are making an accommodation based on a physical requirement. And I would highly recommend a company, if it is not going to create an undue burden for them, an undue hardship, that they allow that additional 2 weeks of leave. And then how they allow it depends. Maybe the company is only able to accommodate that leave for that specific position the employee was in for exactly 12 weeks. They don't have to keep that position open any longer after the 12 weeks. An employee can still be on leave and could return to work in a different position, but their position was no longer protected. The minutia can get really, really huge there.
Yeah, it's almost like a big spider web. They just all intertwine in some way, some fashion. And I know, one thing too. So when does the 12 weeks clock start?
Technically, the 12 weeks clock starts the day the employee has been issued their eligibility notice it depends. So the 12 weeks can start on the day the leave begins if the employee was given all of their notices properly and they gave advance notice for their need for leave. The 12 weeks starts on the first day of their leave. If an employee has actually been off work already for 3 weeks, nobody gave them rights and responsibilities, the company was unaware, then their 12 weeks doesn't start until they've been given the notice of eligibility and the rights and responsibilities. So the employee has to be notified in order for the 12 weeks to begin.
Yeah, we had that happen one time where we were talking to a group, and a guy went out on I think it was a heart condition, right? So went out and had heart surgery, and didn't go well. Joe was going to be out for a couple weeks. We don't need to do all the FMLA stuff, and so he was out. He may have been out 6 or 8 weeks, and the company's coming back going, look, we can't have him out that long. We need to let the guy go. And it's like, well, one, he's got FMLA, right? He has some job protections, but two, when did you give them his rights and responsibilities? And I said, I don't know what that is.
Oh my goodness.
And they weren't a client at the time. But so we were like, so it was, well, you need to give him that. And not only can you not let him go, not only has he already gotten 6 weeks worth of off, now he gets another 12. So he's getting, 18 weeks off because you didn't provide that rights and responsibilities. And so that's always so important, is to let them know, because that clock doesn't start. And a lot of people don't realize that.
That's right. That's right. They just assume that, no, we said they were out on FMLA, so it's FMLA. No, it's not. Unless you provided that rights and responsibility sheet, it's not FMLA yet.
That's
so,
it.
Yeah.
And you're talking about that ADA. We can go on with stories forever. We had a deal one time where a guy was out. He had a condition. I forget what it was. And again, this was a group. They weren't a client. We were just talking to him, and he went out on his 12 weeks, and he went out with a surgery. It was a physical ailment. I forget what it was. It was like a heart condition or something. And got to the end of the 12 weeks, and they're like, if you can't come back, you're out. So they fired the guy. And this was a guy, been there forever. They all knew Joe. He's an awesome guy. No worries. Well, the problem was that he was an older gentleman, didn't have another job. He was incapacitated. He couldn't work. And they did not consider the spider web, the ADA, and all those things. And he came back and sued them, and got a nice chunk of change because they didn't afford him those other rights to get.
Because at that point, the company has to engage in the interactive process with an employee and see if they can make an accommodation. And an extended period of leave is an accommodation under the ADA. Mm-hmm. So if allowing that leave does not cause a huge undue burden on a company, and undue burden is really difficult to prove. If you are a profiting company, it's mm-hmm. hard to say, no, we can't allow him to stay on leave because it's affecting us in major ways. Then you're in violation of the ADA for not engaging in the interactive process.
Right. Yeah. So it's crazy, and again, I think it goes back to a lot of people and companies are just not fully aware of how all this works. And it's so important that they do. And when these issues come up, they get guidance and consultation on how to handle them, because there is a lot of risk at this too, if they're not doing this correctly.
Absolutely. So yeah, that's why we love to answer leave questions. It's one of my favorites.
So, but they can't, so their job is protected, but you can, if they do something else during that period, they can be termed, correct? So if you find out they're stealing or anything like that, so it doesn't totally preclude them. They can't become a bad actor.
Oh, that's right. Yeah, absolutely. So even if, say, an employee was say a company needed to downsize and needed to perform some layoffs, but they have this one person on FMLA, being on FMLA does not protect them from being part of the layoff. It's something that they can't terminate an employee as retaliation for being on leave or for having the medical condition that requires the leave. But if there was, say, if an employee was already being disciplined, there had been multiple write-ups, and it was, of course, all very well documented, and a conclusion of an investigation happened and it turned out the employee needed to have been terminated, then they can still be terminated when they're on leave. Being on leave does not protect them from a termination for a different reason.
Okay. Well, so we've talked about FMLA. What we do know, and we talked a little bit about ADA, which we also know now states and even some municipalities have leave laws. And so maybe from a high level, as an employer, how do I address all these things? How do these things work together?
My recommendation for any employer would be to start with their specific local jurisdiction. Especially if they live and work in a bigger city, check and see if there are any leave protections for the city you work in. Mm-hmm. And then go up to the state level. Check and see if your state has a family and medical leave, paid or unpaid, and then you'll put those protections into place next, and then you move up to the federal. So if you know your state doesn't have any protections, go straight to federal. But I would definitely recommend always looking into that first.
Okay. And I know that's the one thing too, is it's important that from a state perspective that and municipal, that they really understand, well, specifically state, they really understand the nuance of those requirements. Because I know, and we talk about this all the time, I'll be talking to clients that are multi-state that have handbooks, and they just say, well, I know California they provide more leave, or they have a leave protection. I'm just going to use the California one for everybody.
Yeah.
And we know that there's problems with that.
Yeah, absolutely. I mean, there are some states that offer a paid leave where an employee would need to apply into a system and get approval from the state that they live in for their leave. So, California wouldn't come into play if that employee lives in Colorado. And then there are other states some states have higher employee count thresholds. Other states have much lower employee count thresholds on when employees are eligible. In Colorado, you just have to have one employee, and that one employee is eligible for 12 weeks of leave after a period of time.
Yeah. No, and I think that's a great point, because a lot of these, a lot of them accrue differently. And I think there's a lot of employers out there that will say that do that. They just take a state and pick it, and that's what they're going to do. But that's really not going to be compliant.
No.
And God bless them, because I guess that's our business case, right?
Absolutely.
We help with that. So it puts food on the table. So, okay. So what, is there anything that we've missed that you can think of that you wanted to make sure that was important to point out?
There's one thing that's always been really big to me is I think a lot of employers don't know that an employee does not have to request FMLA leave. They don't have to request FMLA leave specifically. They don't even have to request leave in general to be offered the protections of FMLA.
Okay.
So if an employer is a covered employer and they think that there is a medical need for leave for one of their employees, it's the employer's responsibility to provide the rights and responsibilities to the employee, even if the employee has never said, hey, I need to take time off. It's the employer's responsibility to know that the need for leave is there and send the information along.
Okay, so I guess as long as there's I guess if somebody's going out on PTO, I guess the catch is typically that supervisor's going to say, what you doing?
Yeah, absolutely. And yeah, if a supervisor knows that Joe is having back surgery next week, but Joe's only requested PTO for 5 days and hasn't specifically said, I need FMLA, but Joe knows it's Joe's responsibility to tell management, to tell the company that this employee is taking a medical leave and it could be covered by FMLA.
Okay. And I guess the trick to it too is if when we get into FMLA, typically we're talking about longer leaves.
Mm-hmm.
And it's hard to take a longer leave without somebody knowing why.
Absolutely. That's right. Well, and here's a tricky thing. FMLA coverage begins if an employee is only off work for 3 days. So if a company, a covered employer, a large company, has an employee who has called into work on the 3rd day, if that employee is called out because they are sick on a 3rd day, that triggers FMLA protection.
Really? Okay.
And so they can be off work for 2 days, but if they call in after the 3rd day, so they can be off work for 3 days. If they call in after the 3rd day, FMLA is triggered. And that leave is most likely completely job protected. There can be no retaliation. If an employee is only out for 1 day, but the night before they were admitted to the hospital and they wound up staying in the hospital for just 24 hours, that 24 hours can be FMLA job protection, protected because they were admitted to the hospital.
Okay. So let me ask you this. So is that 3 days out? Is that like if an employee no call, no show, they just, for whatever reason, they were out, emergency surgery, it was an emergency with my child. If they just didn't show, if they call in within that 3-day period, it's FMLA?
That's right.
So you couldn't.
That's right.
Okay.
If they call on the 4th day and say, I'm so sorry, I couldn't get in touch with anyone. It was an emergency. I didn't have my phone. But a company can require the physician certification. And if the physician certification comes back and the doctor has signed off, yes, this employee was in the hospital with their child who had emergency appendectomy, then those 3 days are totally job protected.
Okay. I did not know that.
Yeah.
Yeah.
Yeah. It's that 72-hour rule is one of the more interesting facts of FMLA.
So what are there any other nuggets there that you want to drop before we?
I think those might be my big ones.
Is that it?
Yeah.
Okay.
Yeah.
Well, good. Well, I really appreciate you joining us. I think it's a great topic. I think it's a lot of great information. I think that, again, this is one of our, I don't want to say popular topics, but it's definitely one that people call on the most. So I think it'll be very, very helpful.
Yeah. Well, I'm glad I got to have it with you. I enjoyed it.
Yeah. Well, thank you. And I want to thank everybody that listens to the podcast. We really appreciate you joining us, and we'll talk to you next time. Thank you for listening to the MyHRBuzz podcast presented by MyHRConcierge. For more information on this topic and many others, please visit our blog at www.myhrbuzz.com. It's a free resource and has a lot of great information on HR and employee screening related topics. If you like the podcast, please do 3 things for us. 1, leave a review. 2, subscribe to the podcast. And 3, tell a friend. Our podcasts are available on iTunes, Spotify, and many other places where you get your favorite podcasts. If you'd like to provide ideas or feedback on future shows, send us an email at podcast@myhrbuzz.com, or you can reach us at 855-538-6947, extension 108. This is Chris Cooley with MyHRConcierge. Thank you for joining us, and we look forward to sharing more topics with you in the future.